Treason is not the reason for the season. FAQ number 1, what part of shall not be infringed do you not understand? Thank you for your question. Long ago, in a land far, far away, there was a king, who wanted a souffle for his birthday celebration. Since souffles are a finicky dessert, that can collapse from a bump or even a loud noise, the king's chef posted an order outside the kitchen. The king's souffle, being an important part of his birthday tonight. Everyone who enters kitchen shall wear padded shoes and tread lightly. 3 days after the king's birthday, Jack and Jill are at home, in their kitchen making avocado toast. The king's secretary general walked by the window, saw them, and ordered them arrested. He explained that the order came from the king's court and therefore applied to everyone in the land, and the order clearly states everyone who enters kitchen shall wear padded shoes. The Secretary General said that he is a textualist, and that he saw the order clearly applied to every person, to every kitchen, for all time. It is an order, he explained, that shall not give exception, in the slightest degree. The Secretary General then pointed to their wooden clogs and asked, what part of shall wear padded shoes do you not understand? This is as misguided as reading the Second Amendment, ignoring the entire first half of the sentence, and then declaring that the right to bear arms shall not be infringed in the slightest degree. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. The king's souffle, being an important part of his birthday tonight, everyone who enters kitchen shall wear padded shoes and tread lightly. Context matters. The first half of both sentences provide the context for who, what, where, and when the second half applies. Padded shoes shall be worn, yes, but only the day of the king's birthday, only in the castle's kitchen, and only while the chef is cooking souffle. The right to bear arms shall not be infringed, yes, but only for militia service, only for the security of the state. That's the grammatical answer. But the historical answer also makes clear that the founders intended for the right to bear arms in the Second Amendment to apply to militia service only. The Articles of Confederation created a weak federal government. And when Shays' Rebellion flared up, the federal government was broke and had no military to stop the rebellion. Shays' Rebellion ran amok for 10 months before the governor of the state of Massachusetts assembled a militia and ended the rebellion. Shays' Rebellion was the reason the founders abandoned the weak Articles of Confederation and adopted the Constitution, which created a federal government strong enough to stop rebellions like Shays'. Among other things, the Constitution mandated federal access to state militias. U.S. Constitution, Article 1, Section 8, Congress shall have power to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively, the appointment of the officers, and the authority of training the militia according to the discipline prescribed by Congress. U.S. Constitution, Article 2, Section 2, the President shall be Commander-in-Chief of the Army and Navy of the United States, and of the militia of the several states, when called into the actual service of the United States. These militia clauses in the Constitution give Congress the power to organize, arm, discipline, and govern state militias. States have certain authority over their respective militias within their states, but the President can command those militias, and Congress can regulate those militias. Congress's first regulation for militias was the Militia Act of 1792. Article 1. Every free able-bodied white male citizen of the respective states, 18 to 45 years old shall be enrolled in the militia, shall provide himself with a good musket or firelock, a sufficient bayonet and belt, 2 spare flints, not less than 24 cartridges, suited to the bore of his musket or firelock. Musket shall be of bores sufficient for balls of the 18th part of a pound. 18 gauge. Article 3. The militia of the respective states shall be arranged into divisions, brigades, regiments, battalions, and companies, to each company, 1 captain, 1 lieutenant, 1 ensign, 4 sergeants, 4 corporals, 1 drummer, and 1 fifer and bugler. Article 11, Section 4, the militia employed in the service of the United States, shall receive the same pay and allowances, as the troops of the United States, shall be subject to the same rules and articles of war. And that no officer, non-commissioned officer, or private of the militia shall be compelled to serve more than 3 months in any 1 year. The Militia Act of 1792 used the militia clauses in the Constitution so that Congress could create a nationwide draft of all free, white, men, into militia service, and so Congress could mandate how those militias were organized, trained, disciplined, paid, and armed. The Militia Act of 1792 required every militia member to possess a single musket, with an 18-gauge barrel, 24 shot, and a quarter-pound of powder. The Second Amendment was needed to make that possible. After the Declaration of Independence, the Articles of Confederation created a weak federal government with no right to bear arms. States adopted their own constitutions and 5 states had no constitutional right to bear arms at all. 5 states had a right to bear arms for militia service only. And 2 states had a right to bear arms for militia service and for personal self-defense. This was the law of the land for about a decade. The Constitution was then drafted and ratified. It had several militia clauses for Congress to organize and regulate militias and for the President to take command of militias. But like the Articles of Confederation, the Constitution had no right to bear arms for militia service. So if a state wanted to rebel against federal authority over their militia, it could specifically ban firearms for militia service. At which point, the Second Amendment comes into play. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. The Second Amendment protects a very narrow right, a right for militia members to possess the arms the federal government expects for militia service, even if the state has no right to bear arms and outlaws all other firearms. All other arms and all other rights to arms, are left to the state to regulate as they see fit. And the Militia Act of 1792 specified the exact arms the federal government expected for militia service to be possessed per militia member, 1 18-gauge musket, 24 shot, and a quarter-pound of gunpowder. States could regulate all other arms if they so choose, but the Second Amendment mandates that states must allow militia members to possess militia arms, and mandates that states must allow militia members to take these arms to and from militia training, and to war if the militia is activated. So, when the Second Amendment says, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed," the right that it is saying shall not be infringed is the very narrow right for members of state militias to possess the firearm expected by the federal government for militia service. Now, when someone asks what part of shall not be infringed do you not understand, they often hold shall not be infringed as a magical clause that overrides every other word in the Second Amendment, overrides every word in the Constitution. They often push the notion that the Second Amendment is waving a magic wand and promising everyone the right to possess any weapon and ammunition, of any kind, in any quantity, to be carried anywhere they want, and fired whenever they want, and that all these firearms must be accessible without a single scrap of paperwork such as a background check or registration. This magical thinking says the right to bear arms shall not be infringed without regard to any other context in the Second Amendment or Constitution, that the right to bear arms is absolute, and cannot be regulated in the slightest. But this magical thinking makes no historical sense. Drafting the Constitution had been extremely contentious. Fist fights broke out between those for and against it. Many anti-federalists who were against the Constitution only agreed to ratify it as long as a Bill of Rights was soon to follow. When it came time to draft a Bill of Rights, Federalists were concerned that anti-federalists would use the process to completely relitigate the entire Constitution and break apart the Union. Federalists wanted to come up with a Bill of Rights that would generate the least resistance and be quickly ratified by the states. And with regard to a right to bear arms, Federalists weren't concerned about a personal right to armed self-defense or some magical total deregulation of all guns. Federalists wanted federal access to state militias, and they wanted those militias to be armed. Now, imagine you're a federalist, and you're drafting a right to bear arms, and 10 states have no right to bear arms or a right to bear arms for militia service only. 10 states that have to ratify your Bill of Rights have either no gun rights at all, or allow guns for militias only. 10 states have gun regulations at the state level. Would it make sense as a federalist to push a federal right to bear arms that mandates a complete deregulation of all gun laws? No. Such a right would have been adamantly opposed by most states, and your Bill of Rights would not get ratified. And as a federalist, your main concern with the right to bear arms is for federal access to state militias and for those militias to have access to arms for militia service, so it makes no sense that you would even push for such a right. And as far as anti-federalists were concerned, anti-federalists were advocates for states' rights. They wanted states to have more power than the federal government. They did not want the federal government to mandate what states must do. They wanted each individual state to decide for itself. Which is mostly how the right to bear arms worked in 1792. The right to bear arms was mostly a state right. A state could decide to allow anyone to have any gun for any purpose at any time. Or a state could decide to ban all firearms, except for the arms militia members required for militia service. Anti-federalists, i.e. states' rights people, didn't care what the federal right to bear arms said as long as they could control the right to bear arms within their state. Which, for the most part, they could. In 1792, 2 states had a right to bear arms for militia service and personal self-defense. These 2 states gave people more rights to arms than the Second Amendment right to bear arms for militia service only. Which is what the founders intended because the Second Amendment established a minimum right to bear arms. States could allow other guns for other reasons if they wanted to. Or states could ban all firearms except for the minimum required by the Second Amendment for militia service. But the existence of states that only allowed arms for militia service is what spurred the magical interpretation of the Second Amendment to be born. Because people who push this magical interpretation of the Second Amendment want to force all states to completely deregulate all guns for all people under all circumstances with no paperwork. And they know this would never be passed into law, so they reinterpret the Second Amendment to mandate a total deregulation of all guns, and then they use the Supreme Court to push this onto the nation as a whole. Shall not be infringed never meant this. The founders never intended this. This approach is anti-federal rights and even anti-state rights. It is anti-federal rights because it attempts to usurp the Second Amendment and turn it into something it isn't. And it's anti-states rights because it attempts to prevent states from regulating arms as they so choose. In short, it runs against democracy itself. The Constitution mandates federal authority to regulate, discipline, govern, and access state militias. And the Second Amendment mandates that states must allow militias to be armed as Congress decides. That is the right that shall not be infringed. All other arms and all other rights to arms are left to the states. The magical interpretation of shall not be infringed, quoted from the Second Amendment without its full context, comes in many, many flavors. Some of the variations are listed below. Magical, militia means any group of people with guns. No. The founders were clear that the militia was a branch of the military, like the Army and Navy. The Constitution gives Congress the power for organizing, arming, disciplining, and governing the militia, and makes the militia subservient to the President. The Militia Act of 1792 makes militia members subject to the same laws of war as the Army, and subject to court-martial for disobeying the President's orders, same as the Army. Also, private militias are outlawed in all 50 states. Magical, the Second Amendment protects a right to bear arms for any individual. No. The Second Amendment protected the right for militia members to possess arms needed for militia service. And to be clear, the Militia Act of 1792 only mandated that free, white, male citizens be drafted into the militia. Blacks, whether free or slave, were not protected by the Second Amendment. Women were not protected by the Second Amendment. When the Bill of Rights was being drafted, slave states outnumbered free states 8-5. And to get the Bill of Rights ratified required 9 states to approve. In absolutely no way was the Second Amendment ever intended to guarantee every person the right to bear arms. The right to bear arms in the Second Amendment is a right to bear arms for militia service only. And lest anyone forget, the context of the Second Amendment is provided in the Second Amendment. A well-regulated militia, for the security of a free state. Magical, Second Amendment says I can have any gun I want, as many as I want, with as much ammunition as I want. No. The Militia Act of 1792 shows the federal government limited the arms and ammunition expected for militia service to be a single 18-gauge musket and 24 rounds of ammunition per militia member. Individuals were not protected by the Second Amendment to have an armory of weapons and limitless piles of gunpowder. The founders used the Second Amendment to protect militia members to possess a single 18-gauge musket and 24 rounds of ammo. States could ban all other firearms if they wanted, as long as they allowed the arms mandated by Congress as needed for militia service. A weird little idiosyncrasy is that most of the time, people who want to deregulate guns will ignore the first half of the Second Amendment that says the right to bear arms is for militia service. But these very same people will suddenly invoke the militia when they want access to military weapons. Which is rather convenient of them. When states have regulated assault weapons, or tried to limit magazine capacities, or tried to prevent people from owning bump stocks, folks who want to deregulate all guns suddenly remember the Second Amendment mentions that the right to bear arms is tied to militia service, which is a branch of the military, and they argue that means that the Second Amendment protects a right for everyone to own all the weapons the modern-day military uses. But this too is incorrect. While it is true that the Second Amendment protects a right to bear arms for militia service, it is also true that the Constitution grants Congress the power for organizing, disciplining, governing, and most importantly, arming the militia. And after the Second Amendment was ratified, Congress used the Militia Clause of the Constitution to pass the Militia Act of 1792, which armed the militia by requiring every militia member possess a single 18-gauge musket and 24 rounds of ammunition. That's it. That means that in 1792, the Second Amendment only protected a right for members of the militia to possess a single 18-gauge musket, 24-shot, and a quarter-pound of powder. A member of the militia had no Second Amendment right to dozens of muskets and hundreds of pounds of gunpowder. A state might allow it if they chose, but the Second Amendment did not protect individual armories. Would the militia have need more ammunition if they went to war? Certainly, 18 rounds would not be enough to go to war, but it would be up to Congress to arm them. Would the militia need weapons besides a musket if they went to war? If need be, weapons such as cannons could be supplied and manned by the full-time army. Or weapons might be issued to the militia upon activation, but returned to the armory once the war is over. The Second Amendment protects a right to bear arms for militia service, but this right does not override the Constitution that gives Congress the power to regulate what arms the militia shall possess. Magical, Second Amendment protects a right to arms without background checks, registration, or paperwork of any kind. No. The Second Amendment protects a right to arms for militia service. The Constitution grants Congress the power to declare war, to raise and support armies, to provide and maintain a navy, to make rules for the regulation of land and naval forces, to organize, arm, discipline, and govern the militia. The Constitution also states the President shall be Commander-in-Chief of the Army and Navy of the United States, and of the militia of the several states. The Militia Act of 1792 mandated that all free, white, men register for militia service. It also subjected militia members to the same laws of warfare and the same laws for court-martial as the Army. It also mandated that militia members be paid the same as the Army, and that militia members be activated for no more than 3 months per year. People must be registered with the state militia for the state to know who to train for militia service. People must be registered with the state militia for the state to activate the militia in times of war. People must be registered with the state militia to be paid by the state for militia service. People must be registered with the state militia for the state to make sure they aren't activated for more than 3 months out of the year. Congress can mandate that people submit to background checks, fingerprints, and other biometrics, before joining the Army, Navy, or militia. There is not such thing as an anonymous militia. Magical, Second Amendment protects a right to personal self-defense. No. When the Bill of Rights was drafted, 2 states, Vermont and Pennsylvania, had a personal right to armed self-defense. And both constitutions used language to make that right legally clear. That the people have a right to bear arms for the defense of themselves and the state. As a counter-example, North Carolina's constitution at the time stated that the people have a right to bear arms, for the defense of the state. Those are 2 very distinct and different choices of words used in those constitutions, and they have 2 very different meanings. The Second Amendment states, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. When Congress was drafting the Bill of Rights, Vermont and Pennsylvania's constitutions had been around for years. Congressional representatives from Vermont and Pennsylvania would have noticed the lack of for defense of themselves in the Second Amendment. But it would not affect the people of Vermont and Pennsylvania, because the Second Amendment established a minimum right to bear arms for militia service. States could grant more rights to arms if they so choose. And residents of Vermont and Pennsylvania would keep their personal right to bear arms for self-defense after the Bill of Rights was ratified. Therefore, Vermont and Pennsylvania would have no reason to oppose ratifying the Second Amendment even though it protected only the right to bear arms for militia service. Likewise, when the founders were drafting the Bill of Rights, North Carolina's constitution had been around for some time. Representatives from North Carolina would have noticed that the Second Amendment protected a right to bear arms for militia service only, directly in line with their state constitution, and therefore North Carolina would have no reason to oppose ratifying the Second Amendment. But imagine if North Carolina, or similar state, thought that the Second Amendment protected a right to bear arms for defense of self and state. And imagine that state had gun regulations in place that regulated weapons outside of militia members going to and from militia service. Say such a state had regulations against public carry of loaded firearms, and prohibitions against keeping loaded firearms laying around the house unattended. And then representatives from this state see this magical interpretation of the Second Amendment is mandating that all their gun regulations be overturned, thrown out, etc. If this were the case, then the representatives from this state would have many reasons to oppose ratifying this version of the Second Amendment. The Second Amendment getting ratified only makes sense from the interpretation that it protects only a right to bear arms for militia service. States that had a right to armed self-defense could keep that right. States that only allowed arms for militia service could keep their gun regulations in place. The states that had no right to bear arms would be required to allow arms, but only for militia service. If the Second Amendment magically intended for a total deregulation of all guns, it would have been a massive upheaval for most states, and they would never have ratified the Second Amendment. Magical, everyone has a natural right to armed self-defense, that right is unlimited, and we don't need any specific wording in the Constitution or Bill of Rights to protect it. No. This is the point where the discussion has completely disconnected from any basis in law. There is no natural right that is limitless. Your natural right to religious freedom does not allow you to murder someone just because you claim God told you to do it. Your natural right to religious freedom does not allow you to discriminate against blacks at your commercial diner or refuse service to gays at your commercial bakery. Your right to free speech does not allow you to verbally threaten to murder someone. Natural rights are entirely individual. When natural rights meet the rest of the world, trade-offs must be made to make sure the rights of the individual are balanced against the rights of the people as a whole. It is the job of Congress, as representatives of the people, to find the balance between the individual and the people as a whole. You may have a natural right to swing your fist, but it is the job of Congress to pass laws to say your personal fist-swinging right ends at society's nose. Invoking a natural right in an attempt to bypass Congress's job of balancing the rights of the individual versus the rights of society is working against democracy. When a judge invokes a natural right to bypass Congress, they are legislating from the bench, attempting to take over Congress's job. So, the fundamental answer to what part of shall not be infringed do you not understand, is this. Context matters. Grammatically speaking, context for the Second Amendment is right there in the first half of the sentence. Ignoring the first half of the Second Amendment that gives the who, what, where, and when for the second half, and arguing that the Second Amendment calls for the deregulation of all guns, is as misguided as seeing the King's chef's order, and arguing that it mandates that padded shoes shall be worn by everyone, in every kitchen, for all eternity. Historically speaking, context in the Constitution makes clear that the Founders intended for the Constitution to grant the President the authority to command militias and grant Congress the power to regulate and arm militias, and the Second Amendment made sure militia members in every state could possess the arms that Congress mandated for militia service. All other arms, and all other rights to arms were left to the states. None of the states with gun regulations in place would have ratified the Second Amendment if they thought it called for an absolute deregulation of all guns and gun laws. Treason is not the reason for the Second Amendment. Treason is not the reason for the season.